Welcome to the NREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, everybody. Welcome to the show. Thanks for being with us. Today, our topic is corporate structures. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, give us a like and follow our page, whether it be our Facebook page or our YouTube page. We appreciate you subscribing to that, following it, and leave us a comment. Let us know what you'd like to hear about, and we'll do our best to try to answer questions that you might have. With that, we're going to go to Sean, who's got a legal update for us.
Thank you, Andy. So today what I want to talk about is the process and strategies for releasing unreleased mortgages or deeds of trust. So a common scenario that we see with our clients is they put a property under contract, they open escrow, and then the escrow agent comes back and states, well, wait a minute, there's a deed of trust out there that needs to be paid off to close. And so our client, the buyer, goes to the seller and states, what's the status of this lien, this mortgage deed of trust? Why hasn't it been paid off? Why is it still showing? And the seller explains, oh, well, I paid that off 5 years ago. And for whatever reason, the lender didn't release the mortgage or deed of trust. Well, now the title company has to go to the lender or the mortgage company or the servicer of the loan and basically say, where's the release document? And the mortgager or servicer doesn't really seem to care. And the lender has no interest in dealing with this because it's not part of their portfolio anymore. It's been paid off. So why do they care about an unreleased deed of trust or an unreleased mortgage? They don't really care. And a lot of times they'll say, oh, well, we can't find it, or it will take, it's going to take 30 days to research this and try to figure it out. And of course, you want to close escrow. You don't want to spend 30 days while some lender who should have released already is trying to search the records and slow playing you on releasing the lien against the property. So I want to talk just a little bit about some strategies here in Arizona, and that I'm aware of even outside of Arizona, that can be utilized to release that mortgage or deed of trust that is still lingering out there, even though it shouldn't be. So there's one thing to go and demand a release. So in Arizona, if I go to a lender and I explain we represent the seller or maybe even the buyer, and it's our understanding that the mortgage deed of trust has been released, and or the underlying loan that's secured by the mortgage and deed of trust has been paid off, but you haven't released the mortgage or deed of trust. And therefore we need it released in order to close escrow. And I send that letter off to the lender. The lender here in Arizona and in most states has basically 30 days in which to respond and provide a release of the mortgage or deed of trust. Well, 30 days is a long time, which is why, of course, the lender's saying, oh, it'll take 30 days to research, and they kind of give you the runaround and the slow play on that. So another strategy that we employ, and it's a really good strategy, and it works really well, is instead of in addition to demanding a release, we demand a payoff. In Arizona, the law provides that if a deed of trust or a mortgage is still of record, then the beneficiary, or in the case of a mortgage, the mortgagor, the mortgagee, the beneficiary of the deed of trust, which means the lender of the deed of trust, and the mortgagee of the mortgage have to provide a payoff within 14 days of the request. There's also federal law to that effect, which is 10 business days, which is essentially 14 calendar days. And if they don't, then they're subject to damages and potentially an award of attorney's fees for failing to provide the payoff. Well, now you kind of put that lender in a bind because, hey, your deed of trust is still of record, or your mortgage is still of record. And because of that, you have certain legal obligations. You may have been paid off, but if you claim that you aren't, then give us the payoff. If you've been paid off, then give us a payoff and it will reflect zero and we can still close escrow. But you have to abide by the law and you have to provide that payoff within a 14-day period. So now you've taken what is generally a 30-day period to get a release and you've accelerated it to 14 days because a $0 payoff is just as good as a release to the title company. So a lot of times what the lender will do is they'll say, okay, we'll just give you a release of the mortgage. Well, that's good as well. So they release the mortgage or they release the deed of trust. But you have to send this letter the right way. And both under Arizona law, and I've worked with Arizona companies and Arizona residents to obtain releases of paid off mortgages and deeds of trust in other states. And those states are very similar to Arizona, which is this notice has to be sent by certified mail. You have to have a record that it was sent and, some form of tracking with the United States Postal Service in order for it to be valid and binding and comply with the statute. So it's very important that it is sent out that way. But in addition to sending it by certified mail, it should also be sent to every email, every fax number, even every address that you can find for the lender or for the servicer, because you want to make sure that this ends up in the right hands. And the letter is pretty strongly worded saying, hey, you've been paid off and you've not released. That's a violation of Arizona law. We demand that you release. And if you don't within 30 days, then you're going to suffer damages. And you're still, your lien or your mortgage deed of trust is still of record. And because of that, you have certain duties and obligations, which is to also provide a payoff. So we want a payoff. And oh, by the way, now that's 14 days. So give us this payoff. If you don't, you're going to have damages. So you want to make sure that that letter, the way it goes out and with the language that's contained in it, you want to make sure that it ends up in the right hands, because a lot of times it'll end up with somebody who does not know what to do with it. But you want it to move up to a decision maker, somebody who has the ability to work outside of the box that these lenders create for their employees and make a rational decision to resolve the problem.
That raises, I think, an important question. And you mentioned the box, being able to find somebody to act outside of the box. We've all called our mortgage company. We've all called the bank, and we get the same person that we get every time, which is not that person, not somebody who can think out of the box or is authorized to be able to do that. And I don't know that there is a special lawyer hotline that allows lawyers to get to that box. So what is kind of a realistic, if somebody comes to you, and I know that you, Sean, have helped endless borrowers with just this problem, or real estate investors attempting to clear a lien of property that should have been cleared a long time ago. What realistically is an appropriate amount of time for you to be able to work through and find that person who can work outside the box?
Well, it depends. If it's a servicer or a beneficiary that we've worked with before, we can accelerate the process because we already have done the legwork and, use the elbow grease to work up the chain of command in order to identify the right person who's outside that box and has that ability. For example, we've all heard of MERS, right? Mortgage Electronic Registration. They are basically a clearinghouse for mortgages and deeds of trust. So you list them as the beneficiary or as the mortgagee, so that every time that these securitized notes are conveyed to a new holder or to a new servicer, you don't have to record an assignment of deed of trust or assignment of mortgage in every county recorder's office where these mortgages and deeds of trust are recorded. And so you just simply provide a spreadsheet to MERS. MERS updates its records, and then they inform the borrower who that is. Well, MERS being listed as the mortgagee or beneficiary means that they do have the statutory requirements and obligations to provide that payoff. And, they are not allowed to simply say, well, call the servicer. Well, no, if you want to do that, then you need to execute an assignment of beneficial interest of the deed of trust or an assignment of the mortgage and record that and basically come off that document. But so long as you're listed on that document, you have to comply with Arizona law and you have to provide a payoff. Well, fortunately, we've worked with MERS and we have those, connections and people we can speak with. And there's other servicers who, we have those types of connections with that, we've utilized and can continue to utilize going forward.
Well, I think that's a huge benefit and a value right off the bat for an investor, or anybody else who's trying to clear a lien, uh, to find somebody who's already worked through that chain or worked up that chain, and probably saves. I mean, we've all done it, but that probably saves hours of time on the phone just trying to find the right people to work with. So, thank you for that legal update. That's an important one, and we appreciate that. So let's move into our topic today. Today, we're talking about corporate structures. And as some of you know, probably know, Sean St. Clair leads the transactional department at Fowler St. Clair. But he doesn't work alone. And with us today, we have an attorney with Fowler St. Clair, Elizabeth Best. Uh, Elizabeth, thanks so much for joining us. How are you today?
I'm good. How are you?
Tell us a little bit about your areas of practice at Fowler St. Clair.
So I'm in the transactional department, mainly with business or corporate formations, the real estate, doing transactional stuff, and then estate planning and probate.
All right. So I want to get into, let's talk about the corporate structures specifically. And we're going to start out right at the beginning. I get clients all the time that just kind of assume that a corporate structure is what they're going to do because they've been told to do it, but don't really know why or why not, what advantages and disadvantages there are. But Elizabeth, as to you, see as the advantages and disadvantages of buying individually or through an entity.
Well, I think it first depends on the purpose of the property. So if they're buying it as their primary residence, they're probably going to want to buy it individually so they can get the homestead exemption. If they're buying it as a rental or an investment property, then you probably want to do an entity so you can get that protection so that people can't get, if something were to happen on the property, they're not going after your individual assets.
Gotcha. Sean, how oftentimes when I meet with folks, they're worried about asset protection. That's the thing they've heard about, or they've heard about being sued and they don't want all of their assets are exposed. How do corporations, whether or corporations or LLCs, provide asset protection?
Well, it's creating that veil, what we call a veil of protection, right? A corporate veil. So it's basically drawing a line in the sand between your personal assets, your personal affairs, and your business assets and your business affairs. And so what I mean by that is you everything that's you personally, like your personal bank account, your home, if you have a personal vehicle, you keep that all in your name, or if you've done some estate planning, you put it into a trust. And then if you have a business, you operate under that business name and that business structure, and you don't commingle your assets. You don't treat the business as it's you personally. And by doing that, then you create that veil of protection between your personal liability and exposure and your business liability and exposure. A example is, if you're out driving down the street, going to the store to buy milk, and you run a stop sign and you hit somebody, and God forbid, it ends up that they are, seriously injured or killed, and they now have a multi-million-dollar claim against you personally. The judgment very well could be entered against you personally, but it would not be entered against your business because you were driving to the store to purchase milk. You weren't driving for the purposes of going and looking at a property. You weren't driving for purposes of your business, right? You were driving personally. So the judgment is against you personally, but not against your business. Now, let's say hypothetically your business goes out and purchases an item on credit, and your business fails to pay for that item. And now the creditor comes after the business. Well, as long as you didn't personally guarantee that debt, the judgment will be against the business. It will not be against you personally. It will not be against your personal assets. It will not be a lien against any real property that you own in your personal name, against your bank account. That is the corporate veil of protection, the separation between personal and business. And in order to achieve that veil of protection, you have to basically create that separate operation. You can't commingle funds. When you put funds in, they should be documented. If they come from your personal account to your business account, they should be documented either as a loan, capital contributions, that type of thing. The business should have its own EIN or tax ID number. The business should have its own bank account. If the business owns, for example, if you do let's say a limited liability company, and that limited liability company owns real estate, and you're going to lease that real estate, that lease should reflect the LLC as the landlord. It shouldn't be you individually as the landlord. So everything you do should be in the name of the business. Everything you do personally should be in your personal name, and you shouldn't commingle those two.
Well, the way I've always liked to understand it is the law really does see you, Sean St. Clair, for example, as a legal entity, and you are, but Sean St. Clair LLC is a different legal entity. And when you form that, or follow the appropriate procedures outlined by whatever state law dictates the formation of a particular entity, you have birthed, in the eyes of the law, a new legal person. And the law treats that differently and treats the debts and obligations of that person differently, just like that would treat your debts and obligations and my debts and obligations differently, correct?
Correct. Yeah, that's exactly right.
So let's talk about the different types of entities and the different options. So we've got a real estate investor who said, man, we've got deals ready to make, ready to do. We need an entity. We want that veil of protection. What is the best structure to form? Elizabeth, give us the difference between corporations and limited liability companies and how we should understand them.
So they both have, the same purpose as Sean was saying, to keep everything separate. LLCs tend to be more informal. They have less statutory requirements than corporations. They are cheaper to form. They're cheaper to operate. And there's no annual reports, no annual fees due to the Arizona Corporation Commission. Whereas corporations have more formalities. You have to file an annual report. If you don't, you're at risk of your corporation becoming administratively dissolved, and you're going to have to pay some fines. You, with that annual report, is an annual fee with the Arizona Corporation Commission. You have to do annual minutes, annual meetings and stuff with the corporation, and you have to have bylaws which dictate how the corporation's going to function, whereas for LLCs, the operating agreement is optional.
So, Elizabeth, what are you, given that the limited liability company has less formality, whereas the corporation has more formality? In fact, I think that was one of the reasons behind the creation of the LLC, was to reduce some of the formality associated with corporations. What are you seeing typically with clients? Are you doing more LLCs, corporations? Where does that fall out on?
LLCs, definitely. And as I was doing some research for this podcast too, LLCs are the most popular form of entity in Arizona. So definitely more LLCs than corporations.
So, given that corporations, limited liability companies are separate persons in the eyes of the law, there is a requirement for both corporations and limited liability company that a statutory agent be appointed. What is a statutory agent, and why is it necessary to have a statutory agent in a corporate structure, whether it's corporations or a limited liability company?
The statutory agent it can either be an individual or another business entity that is appointed by the LLC or corporation. And the main purpose is to accept service of process. So if there's lawsuits, notices from the county or the city, if it has to do with the real property, those go to the statutory agent. So every corporation and LLC that's registered with the Arizona Corporation Commission has to have a statutory agent. Oftentimes, when we form them for our clients, we'll act as the statutory agent, or they can, if they want to as well. And so it's pretty much any individual, corporation, or LLC that can do business in Arizona is allowed to be one.
So it could be the owner of the business, correct?
Right. You just can't have an LLC be its own statutory agent because that's a little circular. So,
All right. Jokingly, I worked with an attorney once that would advise entities who were formed for nonprofit religious purposes that if it was a pastor, maybe they think about somebody else other than the pastor to be the statutory agent. Otherwise, you might get served with process at the pulpit while you're preaching.
yeah.
So, think about that. If you're forming a company, it seems to me that the investor or the owners of the company ought to think about, who should accept service. Our office, other offices can do it. Lawyers can do it as well. And it really doesn't cost that much. Sean, I want to go to you with the next question. I get this a lot with clients in the creation of trusts. And usually it's because they've got the misguided belief that a trust is going to protect them and do everything that an LLC does. So why don't you explain to our listeners what is the difference between a trust and having a formal corporate formation?
Yeah, and I have the same thing with my clients. They always come and say, I want my assets to be protected. Let's form a trust. And most trusts are not asset protection vehicles. Most trusts that are created are revocable trusts. They're trusts that can be revoked, and they don't have their own EIN number. They use the settler, what we call the settler, the person that creates the trust. We refer to them as the settler, or the grantor is another word for the person that creates the trust. It uses their social security numbers to, report income and losses and that type of thing. And so they're really not separate from the people that created them. And so if a judgment, let's say I have a trust, and I end up injuring someone, they come after me, but all my assets are in my family trust, it doesn't matter. They can pierce that trust and pursue those assets once they get the judgment against me. It's really not something separate from myself. Now, with that said, there's irrevocable trusts that can be created, and different types of special needs trusts and other things like that that could have different protections against creditor claims. But generally, when we're talking about somebody doing an estate plan, a basic estate plan, creating a trust, we're talking about somebody who's creating a revocable trust that is not going to shield any of that person's assets from creditor claims, versus an entity will. An entity has to have, or should have, its own tax identification number, checking account, and it's going to and should operate separate from its owner.
Yeah, and I think it's important for the listeners to understand that a trust is still important. There is a reason for it to keep your assets out of probate, but it doesn't take the place of a formal entity or business, and the two can work together. But it sounds like the point here is a trust isn't in and of itself going to be sufficient to protect you from liability, correct?
Correct. Yes.
Elizabeth, so given what you said earlier, that most of what you're seeing today are clients forming limited liability companies, give us an idea. What's the process? I want to form Andy Fowler LLC. What are the steps?
So first, you're going to want to make sure that that name is available. With the Arizona Corporation Commission, they have a general search that you can run. Oftentimes, like similar names will pop up too. So that's what you'll do first. If you have a name that you absolutely love, you can always reserve the name. If you want to, there's a small fee for that, and I think it's valid for like 4 or 5 months. The next thing is to decide if you want it to be member managed or manager managed. The difference is going to kind of depend on the type of LLC and how you want it run. If you have, husband and wife have a rental that they want to put into an LLC, we usually do member manage. It's the owners have control over everything. Manager manage is there's members who own the company, and then the managers are in charge of running the LLC. So if you have a bunch of investors who want to go in on an LLC, but maybe one of them just wants to put in the money and doesn't want anything to do with running it, then that person would just be a member, not a manager necessarily. And then what you do is prepare the articles of organization. So now everything with the ACC can be filed online, which is our preference because it's much quicker than having to fill out the forms and send them into the ACC. I still prefer to fill out the form and send it to our clients just to make sure all the information is correct. And then you file it online. Once everything is filled out and submitted, the statutory agent receives an email. So if it's our office, we get that email immediately. Someone from our office accepts the appointment, and then the LLC is formed. If it's a client who is going to serve as the stat agent, we let them know, hey, look out for this email. Once you accept it, let us know, and we'll pull the articles. So it's much quicker to form it online now. Following that, you do have to publish, but if it is in Maricopa or Pima County, the ACC publishes for you, so you don't really have to worry about that. And then you're kind of ready to go. You'll want to get an EIN from the IRS, open up a bank account for the LLC, and if you want to do an operating agreement, you'll want to make sure that's done at the same time. But other than that, you're ready to go.
I get this question a lot, usually from clients who have started the process on their own and got to a stopping point because they didn't understand terms. But you mentioned these terms. Explain to our listeners the difference and distinction between a member of a limited liability company and a manager.
So the member is pretty much an owner of the LLC. The manager are the people who are running the LLCs. So they're the people who can sign on behalf of the LLC, enter into contracts, stuff like that, in a manager managed LLC.
Gotcha. As far as additional documents, now you mentioned you file the the articles of organization, those get published. But for all intents and purposes at that point, once you've received approval from the, at least in Arizona's context, the Arizona Corporation Commission, you have a validly formed entity. What is an operating agreement? Is it required, and when is it required?
It's not required in Arizona. You're going to want an operating agreement. So Arizona has default laws for limited liability companies. If you want to deviate from the default laws, then you're going to want an operating agreement. If, for example, someone's putting in more money and so they get a bigger percentage, because under Arizona laws, it's if you have two members, it's split 50-50. Same with if it's manager managed and you want someone to be more in charge or someone to have like a majority, be able to go in and have a majority rule, that's when you're going to want an operating agreement. But the operating agreement basically just establishes how the company is going to be run, the rules, ownership, lays out all of that. So if you are fine with the default laws, you don't need one. But in other cases, and especially if you're going to have a lot of members, I would recommend it.
Sean, I'm going to go to you with this one, but just following up on the operating agreement. Operating agreements make a ton of sense for limited liability companies that have multiple members, obviously, because it's a document designed and created in order to manage that relationship among members. But every once in a while, I'll get a single member uh, limited liability company, and they come to me, and they didn't do one because the formality didn't really suggest that they would need it. And they've gone to the bank, and the bank or some other institution says, "We want to see your operating agreement." Uh, do you run into that? Why do you think that's the case? And what do you do when you run into that?
We see that mostly with title companies. They want to see as part of the acquisition or disposition of the real estate an operating agreement, even though it's a single member entity. In Arizona, not so much, but outside of Arizona, we see it quite a bit. And we go and say, well, it's an Arizona LLC. The statutes, as Elizabeth was saying, they take over. They're by default. We don't need an operating agreement. They say, nope, we want an operating agreement. And it's one of those things where, and I say this a lot to my clients, which is there's what the law provides and what a title company will insure or allow, and they're not always the same thing. And so if the title company's regulations are that you have to produce an operating agreement, then you need an operating agreement. And, in that case, we work with the client to throw together a real basic operating agreement that is consistent with the statutes, but it, meets the requirements of the title company. But yeah, it happens quite a bit where you have these financial institutions, whether a title company, lender, bank, who are not going to be satisfied until they see an operating agreement for that company.
So, Sean, let's move over to the other side of the entity. Does Arizona corporate law have a similar requirement or a similar document for managing the relationship of directors? What's basically the corporate equivalent of the operating agreement?
The corporate equivalent of the operating agreement are the bylaws. So the bylaws are going to dictate the operations of the corporation. Things are a little bit different with corporations and with bylaws as opposed to LLCs and operating agreements. So LLCs have members and managers. Corporations have directors and officers. And so corporations have a board, which would be and shareholders. So, actually corporations have three layers, right? You have your shareholders who are the owners. So those are akin to the members. Then you have your directors. So they serve on the board and they make decisions regarding the operations, kind of a 30,000-foot view decision regarding the operations of the corporation. And then you have your officers who basically carry out the wishes of the board. And so you have those layers. And so the bylaws really dictate or govern the relationship of those layers. They talk about meetings and how action is how the corporation takes action. It talks about the operations of the corporation. What bylaws don't do that operating agreements do in many contexts is talk about withdrawal, or in Arizona, we use the term dissociation of members. So an operating agreement will talk about when a member can basically be kicked out, or when a member can, resign or, terminate their membership. All of that is referred to as a dissociation. Bylaws generally don't deal with that kind of thing. Bylaws generally just are looking at the operations, things like meetings and how they're scheduled, resolutions, the appointment of officers and directors, the responsibilities given to each officer, that type of thing. So they're quite a bit different, but you can do something similar with corporations as you do see in your operating agreement with what's called a shareholder agreement. So your shareholder agreement can deal with those types of things, like it wouldn't be dissociation in a corporation, but things like dissociation or termination or withdrawal of an owner. What happens if somebody steals from the company? It can deal with the right of first refusal for stock ownership and sales. So if somebody wants to sell their stock in the corporation, because that's how you own a corporation, right, is by owning stock, versus in a limited liability company, you own a percentage of the company. You own a percentage of the membership. And so you can buy or you can have a right of first refusal for stock. So if you're going to sell your stock, you have to go to the other shareholders and basically say, hey, I want to sell. Are you willing to buy? And here's the amount that, I'm looking to sell my stock for. I have an offer for this amount. And so all of that can be dealt with in a shareholder agreement. It's generally not dealt with in the bylaws. Bylaws are more basic for just dealing with the operations of the corporation.
Now, Sean, Elizabeth mentioned just a little bit ago that the operating agreement is not a formalistic technical requirement to a validly formed limited liability company. Are bylaws required in the formation of a corporation?
We do have statutes that would fill in, but bylaws are, there's a greater emphasis on having bylaws in corporations, even if it's a single owner, single shareholder corporation, than having an operating agreement in a single member LLC. So bottom line is bylaws are recommended and should be put into place for every corporation.
Elizabeth, I formed my limited liability company. I've received the approval from the Arizona Corporation Commission. I've obtained my EIN. I'm doing business. Everything is hunky-dory. And I went online, or somebody told me that I need a buy-sell agreement. What is a buy-sell agreement? When do I need it?
So a buy-sell agreement is a contract between the owners of a company that dictates what's going to happen upon a certain event, whether it's someone passing away, they want to leave, they become incapacitated, things like that. So it'll establish who can purchase that owner's interest, the price at which it can be purchased, and how either the company or the other owners will pay for that interest. So it really just kind of lays out if someone is going to leave, how that is going to happen.
Gotcha. Sean, one of the benefits that Elizabeth mentioned earlier with limited liability companies is the flexibility and how to structure the ownership, how to structure the control, as well as the ability to choose how it is taxed. Um, and this doesn't necessarily just have to apply to a limited liability company, but could apply to a corporation as well, given a particular person's election for taxation. But what is an S-Corp? And how does that work? And is that an actual type of entity?
Great question. And unfortunately, we see a lot of times our clients have confusion over this. S-Corps are nothing more than tax designations. So an S-Corp is how you designate your entity for purposes of taxation. So a limited liability company can be taxed as an S-Corp as opposed to a partnership, or if it's a single member entity, a sole proprietorship. Uh, you can designate it with an S-Corp status, which has certain tax benefits under certain circumstances that go with that designation. But you do not have to form a corporation to have S-Corp status. And there's confusion out there. And we have clients who don't use us for the formation. And so then they come to us and say, oh, I have an S-Corp and, I want to, um, utilize it in my corporate structure. And so we find out information about it and find out, well, it's a corporation, which we can deal with and we can handle. But all of a sudden you're going from, an operating agreement to now you have to do bylaws and a shareholder agreement just to accomplish that same thing, if you will. And plus then you have to file an annual report. And so I've had a few clients who have created these corporations because they thought it was necessary for the S-Corp status. And then they come to us to do, structuring for them. And they say, oh, I want this S-Corp to be part of my structure. And we look at it and say, oh, it's a corporation. Oh, by the way, you did not file your annual report. And so it is now about to be dissolved, administratively dissolved by the Arizona Corporation Commission. Back in the, I'll say good old days, or back before the state was as, fiscally conscious or conscientious, they would send out by mail to the address for the corporation and to the stat agent a notice that, hey, look, you've not filed your annual report. And if you don't do it in the next 90 days, we're going to take steps to administratively dissolve the corporation. And then you're given an opportunity at that point to go and file your annual report. Well, they don't do that anymore. You might, and it's not always 100%, you might receive an email from them saying you haven't filed your annual report, but they don't have to provide you any notice. And there are periods of time where they don't provide notice. And you just have to put it onto your calendar and know that on this date, it's been 1 year since I filed my annual report, and this is the date that I need to file my annual report. Now you have a little bit of grace period. Like I said, they're not going to go and administratively dissolve the corporation if you're a day or two or even a week or two late on filing the annual report, but it's incumbent upon you many times to figure that out. And you can't rely upon receiving notice from the Corporation Commission. And then there's a fee to file the annual report. It's like $100, but let's say you use that corporation for 10 years. Now you're talking $1,000 that you wouldn't have to deal with or spend if you formed a limited liability company and simply chosen an S-Corp designation for that limited liability company.
Elizabeth, I want to ask you, with the folks that you prepare or create limited liability companies for, is anonymity typically part of the equation or a reason for some or many to form an entity?
It depends. There are some people who definitely want the anonymity for a variety of reasons. So it just kind of depends because Arizona is a public record state. So anyone can go on, the ACC's website, look up an LLC. You're going to see members and managers. Um, Go on the recorder's website, put in a name, you're gonna see, or the assessor's or recorder's website, and, documents will pop up and you'll be able to find things. So sometimes people want to kinda try to hide their assets a little better, and get some anonymity that way.
And by anonymity, I should have clarified probably better, but how would you describe to our listeners what we really mean by anonymity. Why would that be important, or why are some clients interested in that?
They just, if they've gotten into legal trouble before or have, heard about it, they want to make it so it's more difficult to locate their assets. So if you're doing a search, you're not seeing their names pop up. They're kind of hidden from everyone.
So the owners are trying to keep their individual names out of the public record, essentially, correct?
Correct.
Sean, does anonymity provide asset protection in and of itself?
No, anonymity does not provide asset protection. Asset protection is basically provided two ways. And one, and this is first and foremost, because everything we've talked about so far is secondary to a good insurance policy. Nothing can take the place of a good insurance policy. So that's number one. So you want to have, both an insurance policy for you personally with an umbrella policy. And then you also want to have a good insurance policy for your businesses and your business structure with, sufficient limits that are going to provide strong protection for you in the case that somebody brings a claim. The second way of achieving, a certain level of asset protection is what we've already talked about, which is creating that corporate veil of protection, separating your corporate operations or your business operations from your personal operations, and keeping, separating your business assets from your personal assets. I can't pronounce it. Anonymity is nothing more than a deterrent. It basically conceals from the public domain the names of the individuals behind certain companies. Now,
go ahead.
let me touch on this one point, because here's where anonymity really, in my view, provides a benefit or comes into play. Let's say that you're an investor, but you're also a real estate agent. So you're licensed as a real estate professional in Arizona or any other state. But you're out there, transacting business and pursuing leads and doing different things outside of your real estate license. You're doing it to be an actual, principal in the transaction as opposed to representing a party in the transaction. And, you're going to make your proper disclosures in the purchase contract or things like that. But let's say hypothetically, you're reaching out to somebody and you're contacting them to see if they might be interested in allowing you to purchase their property through your entity, right? And that person is on the do not call list, for example. And so they're upset that you contacted them. Now, you haven't contacted them in your capacity as a real estate agent. You've not asked them to list, that whether you can list their property, et cetera. You're trying to enter into a contract to purchase their property. So it's really outside of the scope of your real estate license. But they find out that you are behind the company contacting them, and they decide that they're going to file a complaint with whatever real estate department governs your license. And they go and file that. Well, it's likely defensible, but all of a sudden now you're having to probably hire an attorney, respond to the complaint, explain that you weren't acting in your real estate license, explaining that you've not done anything to violate any of the real estate licensing laws, et cetera, et cetera, et cetera, right? Versus if you had that level of anonymity, okay, somebody on the do not call registry was contacted. There's, statutes that provide what the consequences and remedies are, but those would be something that would be the liability, if any, would be the business. It would not have anything to do with the individual behind the company, right? Because you are acting in your capacity as a business. And so you would avoid those types of administrative hassles potentially by having that level of anonymity in place.
Now, Elizabeth, not every state provides the ability to form an entity and keep its owners anonymous, Arizona being one of those. So if you're in one of those states, like in Arizona, where they require the listing of the members, how do you go about maintaining anonymity?
So in that case, we do kind of a layering of different things. So one way to do it is to first form a holding trust, which will then be a member of a Delaware LLC. Delaware does not require any information. Their certificate of formation is literally the name of the LLC, the name and address of the stat agent, and then an authorized person signs it. So for our office, an attorney here would sign it. You file that. That's all the information anyone's ever going to find out from online with the Delaware Corporation Commission. So what we do pretty frequently is we form a holding trust, which is then the member of the Delaware LLC. And then the Delaware LLC is going to be the member of the Arizona LLC. So the only information disclosed in Arizona is the name of the Delaware LLC. Now you will need an address, but we've had clients who've used our firm's address or, different addresses that they can use for that. But other than that, that's kind of a layered way of doing it. I know Wyoming's kind of the same too, and I think New Mexico as well, as far as anonymity.
Got it. So, Sean, have you found problems at all with domesticating out of Delaware or Wyoming?
Yeah, and that's why Elizabeth mentioned the layering, because she's spot on that. The layering is the most critical component of the organizational structure. Because let's say I go and I form a Delaware LLC and I file that one-page certificate, which lists simply the name of the company, the stat agent, and the person filing it, i.e. the attorney or document preparer, and they sign it. That's who files it. Well, that's all that's of record with Delaware. So nobody can figure that out. Well, now I want to start using that LLC. And I decide, oh, well, maybe I should, buy some real estate in the name of that LLC, right? And so I come to Arizona and I purchase property in the name of that LLC, and the property goes into, my LLC's name. The deed isn't signed by the entity, and so you still keep that level of anonymity. But let's say hypothetically that I put a tenant in that property and I do what I'm supposed to do, and I put the Delaware LLC as the landlord under the lease, and everything's good. Well, all of a sudden that tenant then breaches that lease, and I have to go and pursue a claim against that tenant on behalf of the Delaware LLC. Well, in Arizona, for you to access our courts, not for you, for an LLC or a corporation or an entity to access our courts, you have to either be an Arizona entity, so an Arizona LLC or an Arizona corporation, or you have to be domesticated here in Arizona, which means you filed with the Arizona Corporation Commission articles or a foreign filing and that says, hey, Arizona, will you recognize, this LLC, which is a Delaware LLC, is being able to transact and conduct business in Arizona? And then the Corporation Commission approves that. And then you can file a lawsuit on behalf of that LLC. The problem is, like Elizabeth explained, Arizona's public records are readily available, and you have to disclose pretty much everything about the limited liability company in Arizona, whether you form it here or you domesticate it here. So when you go and you file that foreign registration with Arizona, you have to put down who the member is, who the manager is, and you have to list that. And so all of a sudden your anonymity just went out the window because you domesticated. So the better strategy is to form the Delaware LLC or the Wyoming LLC or the New Mexico LLC, as Elizabeth explained. And that entity sole purpose is to hold membership interests in other LLCs that are formed and created. And it's those lower level LLCs that actually operate. So the Delaware LLC or the Wyoming LLC will not be operating other than to hold membership interests in other LLCs. So then let's run that hypothetical through. Let's say you want to own property here in Arizona, and you want to be able to, pursue lawsuits as necessary related to that property. What you would do is you would form the Delaware LLC, then you would form the Arizona LLC, and the member of the Delaware or the member of the Arizona LLC would be the Delaware LLC. So when somebody looked at the public records for Arizona, they would say, oh, ABC Arizona LLC is owned by XYZ Delaware LLC. Oh, let me go to Delaware and see who owns that Delaware LLC. Oh, well, I can't because I come across one sheet of paper that gives some very basic information and does not identify the members and managers of the Delaware LLC. So you're stopped. That's where you stop. You don't have any additional information. But the Arizona LLC, because it's an Arizona LLC, is free to access our courts and pursue claims here in Arizona.
Interesting. So, Elizabeth, we have real estate investors, a lot of them that listen to this show. So, what are common corporate structures that you typically see for investors with rental properties?
Mainly LLCs still, and then you can have multiple LLCs for the different properties. We often we'll work with their CPAs too, as far as the best tax flow or to have the structure, but have it structured so they have the best taxes that they can. As far as you can have different LLCs in Arizona owning other LLCs. We've definitely gotten them very complicated to the point where we're drawing out the different structures and how everything should flow. So that's pretty common. I encourage clients to talk to their homeowners insurance just to see, because some of them don't want a bunch of rental properties all on one insurance policy. So that's something to think about as well.
What about for investors with multiple businesses? What are some common corporate structures?
So for multiple businesses, just to basically create a separation between businesses. So if one business ends up in a lawsuit or has a claim, it doesn't affect every other business. Is that you would create separate LLCs for each business. So for example, if you have an investor that has a wholesale practice, that wholesale practice would operate under the name of one LLC. Let's say that same investor also does, buy and holds and fix and flips, that type of thing. That operation would be conducted under potentially multiple LLCs, depending on the number of properties that they're, holding and owning at any given time. And then you have maybe another type of operation. Maybe you're a general contractor as well, and you have a general contracting business that works to do the remodels and repairs on properties for you and maybe even other investors. That general contracting business should be in a separate LLC or entity, so that you're now creating that separation, and you shouldn't commingle funds across those entities. If you're going to fund the contracting business, it should either be through a capital contribution from the members or a loan from the members, or if you want some of the other entities to, provide some funds, it should be a loan between the entities documented by a promissory note with interest. And so it's properly documented, so it's consistent with operating each of those business entities separate.
Interesting. Well, we really appreciate you being with us today, Elizabeth. It's been very informative. Where can our listeners find you?
I am on our website and on Facebook.
So
So
our
that-
website is www.fowlerstclair.com.
And you can find Elizabeth on Facebook as well. With that, everybody, that is our show today. Next week we're going to be talking about specific performance in real estate. What is your word your bond? So bringing specific performance actions, and we're going to have attorney Brian Locker on the show for that episode. So look forward to seeing you next week. Have a good one.
Have a good day, everyone.